Carl Llewellyn doing the restatement on contracts. Yes, it was a faithful statement of where contract law was, but it was prescriptive, and Llewellyn and his co-authors consciously sought to move the boundaries outward in a prescriptive way. And last, you have to stay at it. This doesn't get done in the short term. You have to be willing to do it this year, next year, and the year after that. That's the only way that your counterparts on the outside know that you really mean to play this role effectively.
Thanks, Bill. It's very provocative, as usual. John, your own thoughts, observations based on your experiences with these issues.
I am John Nectarline. I am the General Counsel of the FTC, so I have to begin with the disclaimer, which is that I'm here speaking only for myself and not for the Federal Trade Commission. Although I think I can speak on behalf of the Federal Trade Commission in thanking Phil and Paul for putting together such a terrific conference, as always. I'm going to key off of a couple today about a dichotomy that you read about a lot between multi-stakeholder processes on the one hand and government top-down mandates on the other. And I'm going to suggest, and I think some of our panelists have alluded to this, that this is not a binary choice. There are hybrid forms of government multi-stakeholder interactions that produce optimal outcomes. And in particular, things that sometimes look like top-down government mandates are really government-enforced multi-stakeholder agreements. They are similar to settlement agreements that lawyers enter into that are then followed by a consent judgment by a court. I'm going to focus almost exclusively on the domestic side of this, and I'm going to use the FCC as a case study. Bill spoke of the FTC as a convener. I'm going to speak of the FCC as a convener. There are a couple of areas where the FCC has played this role particularly well. One is in the context of intercarrier compensation reform. In that area, there have been a number of occasions over the years when the FCC has said to the industry, look, we have a problem. It's extremely complicated. We are going to look to you to come up with a solution that has credibility and that we can then bless. One obvious example of this that comes to mind is the calls order that the Commission issued in 2000. It is one of the proudest accomplishments of Bill Kennard's tenure as chairman and of Larry Strickland's tenure as Common Carrier Bureau Chief. The intercarrier compensation reform continued through the 2000s. These were processes in which everyone understood that the money that one